This is Chapter 21 and 22 summaries. Chapter 21 talks about employment discrimination, and it starts out with the employment at will doctrine, which is a contract of employment for an indeterminate term that is terminal at will by either the employer or the employee. There's a public policy exemption, which is an exemption to the employment at will doctrine that makes it unlawful to dismiss an employee for taking certain actions in the public interest, implied covenant of good faith and fair. Dealing is an exemption at will doctrine based on the theory that every employment contract, even an unwritten one, contains the implicit understanding that the parties will deal fairly with each other. Then there's constitutional provisions, which is the Civil Rights Act of 1866, which U.S. people have the same rights, and it enforces contracts, full and equal benefit of law. Civil Rights Act of 1871 prohibits discrimination by the state and government, and then the Equal Pay Act of 1963 prohibits wage discrimination based on sex. The proof in employment discrimination cases, there's disparate treatment, which occurs when the employer treats one employee less favorably than another because of that employee's color, race, religion, sex, or national origin. There's disparate impact, which occurs when the employer's facially neutral policy or practice has a discriminatory effect on employees who belong to a protected class. Then there is sexual harassment, which is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that explicitly or implicitly makes submission term or condition of employment or creates an intimidating, hostile, or offensive environment. There are statutory defenses, which is bona fide, occupational qualifications, seniority systems, mixed motives, merit. Then there's protected classes, which are race and color, national origin, and religion. The Age Discrimination Act in Employment Act of 1967 is a statute that prohibits employers from refusing to hire, discharging, or discriminating against people in terms or conditions of employment on the basis of age. Chapter 22 goes on to talk about environmental law. This goes over alternative approaches to environmental protection. There's tort law, which is an injury to one's person or property. And there's nuisances, which is an unreasonable interference with someone else's use and enjoyment of his or her land. There's government subsidies approach, emission charges approach, marketable discharge permits approach, and a direct regulation approach. The direct regulation approach has the technology forcing standards, which is pollution control, and then technology driven standards, which takes into account the limits of technology. There's the Environmental Protection Agency, or the EPA, which is the federal agency charged with the responsibility of conducting an integrated, coordinated attack on all forms of pollution of the environment. And then there's the National Environmental Policy Act of 1970, which is the country's most influential piece of environmental legislation. It's the Environmental Impact Statement, which is a statement that must be prepared for every major federal activity that would significantly affect the quality of the human environment. Then there's regulating water quality, which is the Federal Water Pollution Control Act, which stated that fishable and swimmable waters would be available by 1983, and then the total elimination of pollutant discharges into navigable waters by 1985. Then there were point sources, which is a distinct place from which pollutants are discharged into water, such as paper mills, electric utility plants, sewage treatment facilities, and factories. And then there's effluent limitations, which is maximum allowable amounts of pollutions that can be discharged from a point source within a given period. Then the primary responses from the U.S. for these issues and all of the amendments and acts in ensuring pollution is taken care of is research, conferences, and treaties.